matter to come before the court this morning is State of Ohio versus Matthew Golga. Both sides will have 15 minutes to present our oral argument. If you are the appellant and wish to reserve any time for rebuttal, you may reserve up to 5 minutes. And if you let me know when you get started, I'm keeping track of the clock this morning and can let you know if you're getting into that reserved time. These arguments are being recorded and then they will be posted on the court's YouTube channel. Please keep your voice up and remain behind the podium. You should not use names of victims, minors, children during your oral argument. You can refer to them by initials or generic terms. I will note you are seeing 2 judges in the courtroom today, but you are arguing in front of 3. One of our judges is not able to be here in the courtroom, but will review the tapes and we will conference. We have read the briefs and ready to proceed when you are.
Thank you, Your Honor. Make sure my phone is off.
Would you like to reserve any time for rebuttal?
Yes, Your Honor, I will reserve 3 minutes,
Certainly.
please. Thank you. Good morning. May it please the court. My name is Peter Patakos. I am here for my client, appellant Matthew Golga, and we are here to ask this honorable court to reverse and vacate the conviction of Mr. Golga below on a charge of telecommunications harassment under Ohio Revised Code 2917-21. This conviction was entered after a 2-day jury trial. And throughout the proceedings, from the first pretrial all the way to the closing argument, we insisted that on the facts that were at issue in this case, Mr. Golga could not be convicted of a crime because all of the conduct that was at issue was fundamentally First Amendment protected activity.
Hasn't the Supreme Court already said telecommunications harassment is constitutional on First Amendment grounds?
The statute itself, on its face, is facially constitutional. We have from the beginning, this is an as-applied challenge.
So isn't speech different than harassment?
Yes.
Okay, so aren't there some facts in this case that are different from just plain speech?
In this case, Your Honor, no. We would say no. This case is, and I think this is good news for everyone here, in that this appeal is simple because there is no real dispute about what the facts are that are at issue. And that is 8 phone calls that Mr. Golga placed to the city of North Ridgeville, specifically to its water department. These 8 phone calls were placed over the course of a single afternoon. I believe it was 26 minutes. Between approximately 2:30 and 3:30 p.m., I believe it was a Tuesday. He made these calls to complain, and I think that the specific facts here really illustrate the egregiousness of the First Amendment violation, because we're not just talking about speech as Judge Landinger brought up. This is also, the First Amendment also protects a citizen's fundamental right to petition the government and complain to the government. And here Mr. Golga was complaining, and it didn't really start as a complaint, it started as an inquiry, because he went to make a cup of coffee as he was going to pick up his son from kindergarten, and he found that his water wasn't working. So his wife placed a call to the water department, and he's informed that their water was shut off at their home because he was a bit late paying about $150 on his water bill. He said, I will be here, I get paid on Friday, I'm a little late because we had Christmas, we bought the kids Christmas presents, I'm a little behind, and I'll be there on Friday. Please turn my water back on. This has never happened before. I didn't get notice. Again, that's all undisputed in the trial record. They essentially said, tough luck, you will turn your water back on Friday when you pay us. And he was upset by that. I think that's natural, but regardless, the Constitution protects a citizen's right to be upset at the government. In fact, it is one of the most foundational rights we have as citizens of the United States of America. And I just want to emphasize, there is truly no dispute about what the facts are here. It is those phone calls. And the only evidence of what, besides the parties, Mr. Golga's specific testimony, The only evidence that the defendants offered of what Mr. Golga actually said was on the single voicemail that is in the transcript. We emphasize it in our briefs. And we don't dispute that Mr. Golga used the F word several times on that call. We don't dispute that he was upset. We don't dispute that he was rude. Mr. Golga even said at trial, he's sorry he got as upset as he did. But the Constitution does not allow the government to police manners, especially in this context.
Well, the testimony is also evidence about what he said, not just the phone call, not just the recorded phone call.
Correct, and he testified mostly to what he said. The testimony that came in from the state was just to say, well, it was consistent with what was on that voicemail. They didn't offer any additional detail other than what was on that voicemail. The testimony was clear that they were relying on the contents of that voicemail, and they sought to overlay that voicemail as representative of what he was saying on those calls. Now, they didn't really dispute that when he called the first time, he was polite, and normally asking, why did my water get turned off? Can you please turn it on, etc. He became increasingly angry as they were unresponsive and arguably callous in response to his concerns. And I think the critical point, we laid out reams and reams of case law. There are 5 different ways you can look at these facts under the First Amendment. Many different doctrines, controlling Supreme Court, U.S. Supreme Court and Ohio Supreme Court precedent that makes clear that this conviction can't stand. Sure.
So your position here is that government workers can't be harassed unless there's a true threat of violence?
Yes. Yeah,
so
essentially.
Anybody else in the world there's a certain kind of threshold, but if you're talking to a government worker, then there has to be a threat of violence or else it's First Amendment.
There has to be an actual threat of violence. The standard is set forth in various cases. We cite the Terminiello case. I think that sets forth the clear standard. And, these standards are very ancient and very well developed.
Because certainly there's case law that if you call somebody multiple times or if you tell them to stop calling you, that's telephone harassment. And
Absolutely.
There's no threat of violence there. Or if you use ugly language repeatedly, or if you say something like, I'm going to come down to your house, that's a implied threat of violence there.
Absolutely, Your Honor. And in every single one of those cases, that's a private citizen.
So you are making that distinction that there's a higher level of supposed harassment in order for there to be telephone harassment.
The speech to public officials, especially on matters of public concern, during office hours, directed to a government office, absolutely is entitled to the highest rung of First Amendment protection. The Ohio Supreme Court said this in Bay v. Rosauer, which is a relatively new case interpreting speech in the context of alleged harassment.
And so all the employees are considered public officials because they work for a public official?
Well, he specifically called the phone line that was addressed to the water department. So he was dealing with the people that answered the phone, and it was the proper office for him to call. Your Honor, if he went there and stalked them and said he was going to hurt them and did anything like that, we agree that this would be a different case. If he didn't have a legitimate purpose for his calls, we would agree that this would be a different case. This is the first time, according to our research, and the state did not produce any cases to suggest otherwise. As far as we can tell, this is the first time the telecommunications statute has ever been applied to a citizen's telecommunications to a government office. So, the other thing that I think is very important to emphasize for the record is that on his 8th call, Mr. Golga did get put in touch with someone who addressed his concerns and said, come down here, if you pay us $31, we'll turn your water back on. So he did go to the water department. He gave them the $31. The alleged victims in this case were there. One of them even walked him down the stairs. There was a little bit of conflicting testimony on that about whether she was joking with him. Mr. Golga said she was, but they all were unanimous that he was perfectly fine and peaceful. I think they even said something like he was a totally different man. Because he was understandably upset, as was his right to be, but by the time the issue was resolved, it was within that same afternoon, he shows up there at this office, they deal with him, and they turn his water back on. There were absolutely no issues. So essentially the city of North Ridgeville is asking this court to cross what we believe is a very dangerous Rubicon by applying this telecommunications statute for the first time to a citizen's complaints to a government office. Now, again, I do think it's a very good question. Had he said something else, had these calls gone on longer than the course of 26 minutes on a single afternoon, then maybe it would be a different case. But in this case, the constitutional protections are clear. And there are 5 different levels. There are 5 different doctrines, at least, that this court could look at. We start with just the fundamental right to petition the government. The Middletown case by the Ohio Supreme Court recognizes this is among the most precious of liberties safeguarded by the Bill of Rights. Laws that affect the exercise of these vital rights cannot be sustained merely because they were enacted for the purpose of dealing with some evil within the state's legislative competence, or even because the laws do in fact provide a helpful means of dealing with such an evil. I think here they're talking about real evil, not someone who's upset because their water was shut off and they have 2 kids that live in their house and they don't know why. I also think it's relevant that the manager of the water department specifically admitted at trial that this was a new policy, that they were doing shutoffs in a more draconian fashion because they wanted to increase their revenues. So in a very real way, they were putting the screws to him. And he was upset. He uttered some profanities. He was mad that they hung up on him. He's mad that he is now, being the guinea pig on this new policy. We're going to increase revenues by shutting people's water off faster without notice as well. It is a I can't say it enough. It's a fundamental right to complain about that, and the Constitution does not allow the government to police people's manners when they are protesting. Again, unless it is a true threat, and here we cite term in yellow, clear and present danger of a serious and substantive evil that rises far above public inconvenience, annoyance, and unrest. The true threat standard of Virginia v. Black, quote, a serious expression of intent to commit an act of unlawful violence to a particular person. The Second Circuit has interpreted this. In another case we cite, the threat has to be so unequivocal, unconditional, immediate, and specific as to the person threatened as to convey a gravity of purpose and imminent prospect of execution. They invited him to come down to give them $31. So it's just very clear that they're not even close to meeting these standards. Now, I understand why a government worker would be upset when someone's mad at them. And this is just our Constitution, our values, we pick and choose here. We say that the citizen's right to free speech, the citizen's right to petition is more important. And this even goes to where there is an actual evil at issue here. There's no evil at issue here.
And Council, I just need to let you know you're now reaching into that 3 minutes of reserve time. You may continue or reserve as you see fit.
I would just briefly mention, the jury was confused in this case. We had a deadlock jury. The trial court refused to instruct the jury on the First Amendment, refused to include this court's warning in the State v. Shuck case that specifically warns that this statute presents, quote, a substantial burden to the prosecution to ensure that the statute's scope is limited to criminal conduct and not the expression of offensive speech. The trial court let Mr. Golga be punished for bad manners, and they did so in the context where it is clearly recognized by the Supreme Court of Ohio, the U.S. Supreme Court, over and over again, that the speech at issue in this case is entitled to the highest rung of First Amendment protection. Therefore, we ask for reversal, and I will rest subject to my limited time for rebuttal. Thank you.
Thank you. You'll have just a couple seconds over 2 minutes.
Thank you.
Thank you, Your Honor. May it please the court, Sean Kelleher, on behalf of the City of North Ridgeville and the State of Ohio. To begin, I guess I would point out that there was by my client, and these are, by my opposing counsel, and convinced from the first pre-trial all the way through trial, all the way to here. I will tell you that no one told Mr. Golga tough luck. We did dispute that he was abusive on the first phone call. I was pleased to hear my opposing counsel agree that
Abusive in what way?
abusive in his tone, tenor, content of his speech, Your Honor. He was shouting over them. They were trying to give him two particular ways to solve his problem, and he either wouldn't listen to let them finish, or he dismissed their offers of help at that time because of the COVID pandemic particularly, but also it remains today. There are two organizations in, that are available to residents in North Ridgeville and surrounding areas through Lorain County as well as North Ridgeville. And what you do is when we find somebody who needs a place to stay or needs a quick loan or needs something for their purposes, they call these two organizations, and those people will briefly interview them and then call and say, hey, we're making a pledge. And they would have said that, we're making a pledge on behalf of the appellant, and they would have turned his water on the next day. But because he was so obviously intent on abusing and intimidating and harassing the employees of the water department, that's how he thought he was going to solve his problem, and he was not interested in hearing how he could otherwise solve his problem. So he resorted to screaming, using the F word, and essentially talking over them where they couldn't get a word in edgewise. So at some point they would hang up. But unlike other places, they can't not answer the phone. They're his only chance to solve his problem. Nobody else is going to be able to turn his water on for him, so they hope against hope that he's calmed down, and they pick up the phone again and they get the same verbal abuse. And what was lucky, I think, for us in this instance is that during a period when they had terminated a phone call, and perhaps they were talking to other residents with calls that were coming in, Mr. Golga called and he left a specific voicemail, which I think includes a threat. And if I may, Your Honor, I know it has some bad words in it, but I think it's important to go ahead and read it verbatim. This is the voicemail that was captured because no one had picked up that particular call. You can't just be hanging up on people. This is fucking bullshit. If you're trying to fucking kill me by turning my fucking water off, then fuck you. If you would like me to come down to the fucking thing, we can have a fucking conversation. Go fuck yourself. You think you're fucking bad? Yeah, fuck him. Let's starve him out. Let's fucking kill them all. And then he concludes by his voice really, really rising. Fuck you. And he hangs up. So this is the kind of abuse that we had the, particularly Tara Pete, who is the utilities director, and the accounts payable clerk, Lisa Diedrich, testified that all of the calls were like that. They couldn't get a word in edgewise, he wouldn't listen, and he wouldn't take their advice. He was just trying to bully and intimidate and harass them into turning his water back on.
How is this different, counsel, from the many cases where law enforcement officers encounter the same sort of response to their job, and the court has found that it is not disorderly conduct or not one of these criminal acts to respond in such a way, even if it's helpful behavior that's being directed to you?
Well, I think the court has separated telecommunications harassment from face-to-face confrontation, but in a real sense, I mean, police are are armed, are ready to take that type of abuse. They're in the moment, and I would say that this is not the type of behavior that what should be encouraged, and it's not, because the statute for anyone that is at the other end of a telecommunications device. Now, there was a lot of citations of really tepid and lukewarm types of things where somebody posted on a MySpace page, whether it's Shuck or Ellison, a single post. That's not the same as picking up the phone and hearing what is essentially and the term was used in the trial, a psychopath screaming into the phone when you work in an open lobby in an unsecure building when you are right there. And so I would just I have certainly charged people with this kind of conduct against a police officer for obstruction of official business. That's available, but as the telecommunications harassment, I think it's just factually in a different world, Your Honor.
I have a question about how the First Amendment issue was raised. It looks like in the briefs you say it was raised in Rule 29. Was it raised specifically as applied challenge, or was it an attack on the actual statute? Do you know that?
As I recall, it was raised as an attack on the actual statute. I have the transcripts, but I don't remember it particularly. What I do remember, Your Honor, is that when we started this off, and things went very slowly, took almost 2 years to bring to trial. When it started off, the very first meeting with whoever I was meeting from Mr. Patekos' firm, and I think I met with 3 different lawyers in different pretrials. And each time they would mention the First Amendment, and I would say, did you listen to the phone call? And the response was always an unconvincing, yeah, we listened to the phone call. This is the First Amendment. And each time, the judge and myself would say, well, we'll look forward to your brief. We'd like to, you can brief that. And it's actually in the record prior to trial when at the late date, Mr. Patekos thought, Mr. Patekos thought that maybe I should brief this, that the judge told him, no, we're going to trial on this date. It was probably within a week. So if that was his firm belief, and criminal rule, I think 12, tells us that the court, who can always control its own docket, would prefer that motions that would divert a trial, solve a trial, cause the necessity for a trial to be canceled, I guess, would prefer those things done by motion. So the court asked if Mr. Patekos was going to brief that several times, or whoever his cohorts were that showed, but they never did. So this was a strategy, and Mr. Patekos raised First Amendment to the jury in his opening and his closing statements, and the jury was just unpersuaded because the phone call is so compelling.
So and opening, closing in 29, or just an opening and closing?
I think it is Rule 29 also, Your Honor. And I have the phone call if the court would like to hear it. And again, that's because this is fact specific.
I'm assuming the phone call, the recorded phone call, is in the record. Are you referring to something other than the voicemail phone call?
No, ma'am.
Okay.
No, Your Honor.
So if it's in the record, we will have it when we are reviewing the case. So we will be able to hear it.
It is different to hear it than it is to see it on the sanitary page. The defendant is, the appellant is out of control, and he placed there was real concern make an exception for him that they don't make for others. I would say that it's very clear, and I think the jury found the call to be every one of those things: intimidating, abusing, and harassing, Your Honor. And within that, remember that within that, there is the threat. When he's at the top of his lungs, at his full throat, he says, if you'd like me to come down to the fucking thing, we can have a fucking conversation. It is clearly threatening. So threatening speech is not protected, and I've never believed that this was a First Amendment case, Your Honor. There were half a dozen pre-trials, offers were made, offers were spurned. So if the court's clearly aware of the facts from your questions, but do you need to hear my statement of the case, or is there any subject to your questions, Your Honor?
I don't, do you have any other more
I
questions?
don't have any other questions, whatever you'd like to say with your time.
I think, Your Honor, I would just point out a few things, tell you that I thought in our brief, we highlighted the cross-examination of the chief of police, who was initially called. He's the first guy they call when something happens in City Hall, because he's up in his office, he's not out on the road, the response is quicker. You know, he's a 28-year veteran at the time. He's done everything from being a road dog to a detective to a school resource officer, and he'd been the chief for 11 years. He's very good at applying the facts to the statutes and citing those people that need to be cited. But the dialogue, I thought, between him and the question and answer was, why did you think the purpose was to intimidate, harass, or abuse? And the chief said, well, on the one call, the taped call, obviously there was no mention of any type of resolution whatsoever. There was no, how do I get my water turned back on? It was, I'm coming down there, the F-bombs. In other words, there was no question. There was no, how do I resolve this matter? All it was basically simply anger. It was intimidation. It was harassment. It was abuse. There was no question. There was no legitimacy to the phone call at all. Your Honor, the telephone harassment, telecommunication harassment statute has been tested. It has been attacked. The defendant uses Shuck and Ellison, which I tell you are not on point for purposes of jury trial instructions. I would say that we felt, as we do, and we still do, that this court, we respectfully ask them to uphold the appellant's conviction in the lower court. There was no relevant constitutional issue that supports the reversal of the lower court, and there was sufficient evidence to support the guilty verdict. I hope you do get a chance to review that phone call. Thank you.
Thank you, counsel. You have 2 minutes and 6 seconds.
Thank you.
6 seconds.
Just to first briefly address the waiver argument, I just think it's based on a fantasy and a completely unrealistic misrepresentation of what it's like for a defendant against the state who's being prosecuted by the state. The obvious fact is, we don't know what their evidence is until they put their case on. We asked them to explain what their evidence was, but we never knew what these alleged victims were going to say once they got up on the stand. We tried to convince them to listen to reason. We had our idea of what the facts were, but ultimately a motion to dismiss was going to be denied because we didn't have a record to work with. So as soon as we said very clearly from the beginning, including opening argument, about their fundamental right to petition, the right to be rude, the right to be vulgar, the importance of these protections, and the importance of the true threat standard. Once their evidence came in, it was clear. They didn't have anything else but those 8 phone calls, and really the specific quote that he read just to this court. So that was the appropriate time to make the Rule 29 motion. We made the motion, the waiver argument has to be rejected. Additionally, this court has a very important duty to uphold the Constitution. If this court holds that a citizen who gets upset at a government official who arguably doesn't do their jobs, it is a Pandora's box that is being opened. It is a very slippery and dangerous slope, which is why we have amicus briefs from some of the most distinguished First Amendment law professors in the world.
So if Mr. Golga was mad about the questions we're asking and he came up to this court and started saying the same thing he said on that phone call, would there be criminal penalties involved?
Arguably, it's disorderly conduct because you have a time, place, and manner issue.
But we are public officials.
It would be an interesting question, Your Honor. If he stood up here and interrupted these proceedings, that would be pretty wild. It's a lot different than making a phone call after your water was turned off. But I think a lot would depend on what he said. I don't know what disorderly conduct is a separate thing, and it's not really at issue here. I just want to say in closing that I think it's very telling that he wants you to listen to the actual, he's emphasizing the tone. He's full of opinions and interpretations about what this voicemail sounds like to someone. The Constitution is clear. Doctrines that have been developed over 100, 200 years are clear that this court cannot consider those things. It cannot consider whether he was rude or profane. The court has to consider whether his conduct represented a true threat.
You are out of time, thank you.
Okay, thank you, Your Honor.
Court will take the matter under advisement. We will issue a written decision in due course, which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website. Thank you, gentlemen. Enjoy this day.